courts differ and some circumstances differ. But the lawyer can explain your rights to you, explain the nature and consequences of the charges, and can enter a plea on your behalf once the lawyer is formally retained and then able to enter a letter of appearance to the municipal court. So at that point, it's an individual decision, really, whether to retain an attorney or not. Of course, we urge it whenever possible. But seriously, most people, when we look at that decision, it tends to do with the nature of the charges. If they're serious and they're things where you want to explore defenses because of the charges against you, or you feel that you can defend the charges, then an attorney is there and is able to handle the municipal court process. Sometimes with things like speeding tickets, moving violations, the points are such that the person says, well, I'm going to go in and talk to the prosecutor and see about lowering them, but I've talked with my insurance company and the consequences are not going to be serious enough that I feel like I need counsel to help me out. I can say that one of the developments I've noticed, particularly in the last few years, is that's actually happening less and less, because the consequences on your insurance, your automobile insurance, of any points for most people have become pretty serious, to the point where it is cost justified, to hire counsel, even for things that, years ago, I'd say 5 years ago, I've been in practice for about 15 years now, and all of that has included a substantial municipal court practice. But really up until about 5 years ago, people didn't retain me that much for speeding tickets unless they had really bad records or a really bad speeding ticket, like 5 points or more. There was a bad situation, or they were adamant about having a defense. But with some changes that are too complicated to go into, but essentially the threshold where you can start seeing your rates go up for a while, like a 3-year time period, for any kind of points on your automobile insurance.
So that means, just so we understand, I get a ticket,
yeah,
and I pay the ticket.
Yeah.
It may not be over, in the sense that I have to pay for insurance costs that are additional because I now have points on my license.
Absolutely, absolutely. We're getting into a little bit more depth in an overview process, but I think we should, because it's probably, the most common type of charge that comes up for most people who would ever go to a municipal court. Would be your basic moving violation, and that would be speeding, failure to yield, failure to stop. Those are the standard tickets. There's the cell phone ticket now, but that's not really being written that much, and there's no points associated with that. So something like a speeding ticket now, when you either plead or are found guilty to a speeding ticket, let's say you're going 20 miles an hour over the limit, that's a 4-point ticket, because the threshold in New Jersey is 1 to 14 over is 2 points, and 15 to 29 is 4 points. Anything over that is 5 points. So you're going 20 miles an hour, okay, and you get a speeding ticket. It's a 4-point speeding ticket. Could be a real problem on automobile insurance. So now what people want to do is see, can I get that 4-point ticket down to a 2-point ticket? And let's say there's no defenses. You were speeding, the trooper paced you, and there's nothing wrong with the speedometer, or he got you with the radar, and the radar was working properly. And this would be back to the question of what do most people want to do. You say if you have 4 points, you at least want to go in and plead not guilty and see about a plea agreement. Well, maybe you can get it to 2. So most often, even if people aren't going to contest the charge or going to plead guilty, they at least want to go in and try to minimize the consequences if possible, and see if there's the ability to do that, and if the prosecutor is willing to do that, or there's a basis in their case to do that. And then the best thing would be to go to 2 levels down and go to 0 points. But what we're talking about are motor vehicle points that are associated with individual moving violations. That's why we, well, it's not what we call them moving violations, because they have to do with moving, but all moving violations have points, essentially. And what that means is those are points that go on your motor vehicle record. So you get a DMV record, and you have points for tickets that you get against you. There's some things that are, aren't like speeding, or there's other charges that can give you points also. But there's a point schedule that's on the DMV website. You can look at what all the tickets are. But back to the speeding ticket analogy, you get a 4-point ticket. If you are only able to reduce that to 2 points and you plead guilty to a 2-point ticket, DMV, when you run your driver's abstract, which is just your history of your driving, it's going to show that you have 2 points. Now, mostly with the DMV, that's not a big problem. It's not until you get to about 6 points that they start possibly surcharging you, which just means you get a bill from them every year. You have to pay a yearly surcharge in addition to whatever you paid in municipal court. Okay, at 6 they start surcharging you, and somewhere at 12 is the threshold for starting to suspend you. essentially. They can actually take action on their own if they feel like you're a habitual offender, even before you get to that many points. If you got a bunch of tickets in a row, they can actually suspend you based on, a claim of being a habitual offender. But for our discussions today, usually points, you have to start really racking up a lot before you start getting into trouble with DMV. But your insurance is different. Your insurance also keeps points against you. They keep an assessment of points against you. And they are allowed to use the same points that go on your DMV record, the insurance company is allowed to use against you. They're called insurance eligibility points. There's actually a place on everybody's policy where you can see how many you have or if you have any. You just have to see where you can read them on your policy or call your agent and ask them. And they get to assign the exact same thing that goes on your DMV record goes on your insurance record. So if you get 2 points because of a speeding ticket, goes on DMV record, your insurance company can say, we've got 2 insurance eligibility points against you. And that may or may not affect your rates, but let's use a better example, 4, 5, that kind of thing. And then when they start getting enough points, they can move you among the tier ratings and actually increase your insurance.
So in theory, I could get stopped, and I can go to court and pay for a ticket, and if there are points associated with the ticket, and I currently have points on my license, I could be paying surcharges to DMV after having paid a fine to the court and then have to pay higher insurance in certain circumstances.
Yeah, absolutely.
Okay.
Yeah,
so bring us back into the courtroom then. If we decide, you know what, there's some consequences that I'm facing, I'm going to get an attorney, first appearance is over, what happens next?
In between the first appearance, well, at the time the attorney makes the first appearance, under the court rules, he or she also makes a demand for discovery. And that's just the letter to the prosecutor saying, hey, I want you to send me discovery. It's a term that means all of the materials the state has to use against you. Okay? It's a legal requirement that the state has to show you any kind of documents, anything that they may use against you, any information they have, even if it's information that could prove your innocence. They have to give up everything that they have in their possession. So you make a demand for discovery. Mostly it's police reports, copies of the tickets, maybe the back of the tickets, there's notes by the officer, or by the way, say officer or trooper, if you're on one of the highways. And that might help the lawyer understand what's going on and whether there's a defense. So we make a demand for discovery, and then we can then review that discovery and apply it to the applicable law and find out whether we think there's any kinds of defenses to the given situation. So then we will work on the defense.